Hello, everyone. Thank you very much for being here today for this masterclass on new trends in allocating contractual liability, not for naught versus hold harmless clauses. Today, I have the honor to present our great professor and teacher at Australian University, Maria Consuelo Conti-Toutin. She has a Bachelor of Laws from the University of Buenos Aires of Law, obtained in 1993, and an LLM from King's College, London, obtained in 2001, and a postgraduate degree in the regulation of financial markets from the London School of Economics, obtained in 2001. Consuelo is an Argentine lawyer specializing in international commercial law with more than 25 years of experience in the United States, Brazil, United Kingdom, and Venezuela. She's also a university professor with more than 20 years of teaching experience, both at the undergraduate and graduate levels. She is currently the director of the postgraduate practical and intensive course in legal English and the contract drafting workshop at Australian University. She's also the academic coordinator and a professor of the postgraduate diploma in hydrocarbons law, organized between Australian University and the University of Salamanca, Spain. At the undergraduate level, she teaches common law institutions at Austral and other classes in institutions such as the University of Buenos Aires, at the School of Law and the School of Economics, Torquato Di Tella University, and Universidad del Museo Social Argentino, among others. Consuelo is proficient in several languages, namely English, French, Spanish, Italian, Portuguese, and Turkish. Consuelo, thank you very much for being here with us today to enlighten us on this topic, and the floor is absolutely yours.
Thank you, Mariano. Welcome, everyone. Good afternoon. And let me thank you for that great presentation. I'm not sure, well, I'm sure I don't deserve it. We will have this whole class delivered in English. I will speak in a British accent, receive pronunciation, and slow pace so everyone can understand. I'm going to share with you the presentation. Please let us know if you can all see that presentation correctly and if you can listen to me. If you have any problem or you experience any trouble within the course of the presentation, please let us know throughout the chat or through reactions. We are going to answer questions at the end, okay, of the presentation. So today I'm going to talk about what's happening right now in this world with this new reality, post-pandemic reality, and a little bit the barriers and the frontiers have erased more, even more, and globalization is more easy. And what people and companies are trying to achieve and people are trying to do is actually to, what we say in English, to have the cake and eat it too. We generally say that you cannot have the cake and eat it, because if you eat the cake, you're left with no cake. But actually, the idea here is that with this barriers being sort of erasing a little bit, it's very easy to contract with someone from another country. And it's like we have access to actually hiring anyone with one click. So your competition is everybody. So what do people want? Again, what do companies want? They want to have their own rules, rules they know, and actually pay what they want. So what happens with a lot of small businesses and also professionals in Latin America is that actually we are cheap and we are attractive, but it is important to understand the rules that our clients need us to follow. Why? Because a contract that's construed in accordance with the common law and that has a law that actually has its roots and follows the common law principles, such as the law of the United States, any state, there is a particular exception of Louisiana, but United States, that they don't have a civil code. There's the UCC, the Uniform Commercial Code, and that's it. Or the UK, I'm going to make references only to the US and the UK. But if we have an agreement construed under those premises that also has governing law, one of the laws that follows any law that follows common law, we will find that the rules are different. Okay, so first thing, we have to focus that this contract that we will have will not be the typical contract construed under the Roman-based civil law system. Why? Because actually, those countries that have civil law systems actually have a lot of the different problems solved in the law within the civil code or the civil and commercial code, depending your own country. So first thing, we have to set our minds that we are looking at a contract that's construed and that will be governed by and in this particular case of this masterclass, I will talk about contracts under British law and under law of any state of the United States. So let's take a look at how these kind of contracts are construed. So we have a general structure that we have a first part, which is the preamble, que es lo que llamamos en español los considerandos, perdón, el encabezado. Los considerandos son los recitals. And the preamble and the recitals are not enforceable, we say. Why? Because actually anything that actually can trigger breach would be part of actually the main part of the contract. Then we pass to definitions, conditions precedent, and take a look at how it's written. It's not conditions precedents, and that's a common mistake within Latin lawyers. It's conditions precedent, okay? Because in English, actually, the adjective does not follow the plural, okay? Representations and warranties, considerations and covenants that are what we call the action sections, remedies, that is what we will talk about during this class, particularly we will look at remedies because this is a particular class about remedies, term and termination, and then we have the boilerplate or endgame provisions that actually are a number of clauses that are very important, such as, for example, clause majeure, severability, language, and so on and so forth. So please take a look carefully at the boilerplate when reviewing an agreement, because loopholes may appear there, okay? We talk about loopholes cuando hablamos de un hueco en el contrato, o como diríamos en español argentino, por donde se escapan las tortugas. And annexes, exhibits, and attachments that may or may not form part of the agreement, whether there's within the boilerplate a special clause called entire agreement or not, okay? So let's talk about remedies, okay? Now that you know how a contract is structured, let's talk about remedies. What happens if a party breaches, okay? So we have the injunctive relief. We have the specific performance, which is not understood under the law, as is with many civil law system in many countries, many Latin countries, most Latin countries, and most countries that actually take their civil law from the French code do have specific performance included in the legislation, not in the case of those contracts construed and governed by the British or the American law. Monetary damages, repair, or limitation of liability and mitigation of losses. And we're going to talk about that more in particular. So what are the remedies for the breach of contract? Breach is incumplimiento. I'm going to switch English and Spanish, as many of you, I don't know exactly the level of English. So at any moment, if you want to actually pose a question in Spanish, you're absolutely invited to do so. So if you feel more comfortable in Spanish, then please do so, okay? So let's take a look at the remedies for contract breach. Most agreements that we are used to, okay? It's unnecessary to include remedy for contract breach. Why? Because actually the law gives me the answer. But unlike civil law, when I have an agreement that is under a law of a country that follows common law, then actually the harmed party will be entitled to damages insofar those remedies have been previously agreed upon, and with the limits those damages, but actually those that compensation for damages will have, okay? So first we have that the interpretation of the agreements under common law is far more narrow, far more stricter. Why? Because we have the criteria of the 4 contracts of the law rule, basically pacta sunt servanda. What the parties agree among themselves is for them actually what will regulate their the relationship. Of course, there are some exceptions to this. Public order, whether there is an employment a relationship, whether there is, and we will talk about that, gross negligence, willful misconduct, or a tort and war, okay? But actually, under common law, the harm party will be entitled to damages, but not a priori to specific performance, as in most of our civil system. Okay, so in the case of the common law systems, actually the specific performance is an equitable remedy that's granted by the court. And then we can speak more about equity. Unfortunately, there's no time, but specific performance is considered an equitable remedy and must be in the common law jurisdictions granted by the court. Okay, so as an entitlement to damages often does not protect the harm party interests adequately, then the parties generally agree upon ways to create an adequate compensation for damages that works for both parties. As I said before, at the beginning of this class, the new modern approach is, I want to contract with you, I want to hire you, but I don't trust your legal system, I don't trust your country. If my money is good for you as my contractor, then I will take care of my own losses for damages and you take care of yours. That is the new position. And to cover that new position, what the market has done is they've gone to a type of clause that I had drafted many times because I've worked many years for the energy sector, and that a clause that was used for the offshore and basically for very risky, for offshore explorations and risky businesses, that's called the knock for knock. We will see what is the knock for knock and how it applies to an agreement and how it's used nowadays in services contracts, and why it has direct impact in your future business, okay? Because either you will get an agreement from a client abroad that will include a knock for knock, or you will be asked to assess. Okay, so let's take a look at the remedies depending type of damages. Basically, we can classify damages in direct and indirect, okay? Direct damages will need full indemnification or what we call liquidated damages. Remember that under common law, penalties are not permitted. So we generally draft a special clause that's called as liquidated damages and not as penalty. Liquidated damages have to actually bear a corresponding relation to the actual damage or to the damage that the parties calculate that one or the other will suffer in that specific breach. Something that's very common, it's to cap, poner un tope. That's CAP, not CUP. As this is a cup, and that's a cap. That's the hat. A cap is also a limit, a threshold on damages, okay? Very common. And direct damages are not so common, okay? And quite controversial. And this will depend insofar as you have adequate insurance. And if some damages, as for example, punitive damages in some states in the United States, in the case of, for example, vicarious punitive damages that are not insurable, then probably won't be even possible to collect those, okay? As punitive damages are more related to class action and are granted by court. So consequential, special, and exemplary damages, loss of profit, business interruption, or loss of business, or loss of opportunities generally are expressly excluded, okay? So again, we go back to our first premise. What do parties want? Very simple, to have their cake and to eat it as well. So they want to allocate risk beforehand. They want to know everything beforehand and set it straight. So to cap losses and get adequate coverage if those losses are too high for them to bear that risk. And of course, to avoid litigation and litigation costs, as litigating in a foreign jurisdiction is not only costly, but also uncertain, okay? So let's talk about limitation of liability, which is what our parties want, and both parties, actually. So most used clauses as indemnity, and we'll see that in a minute, the hold harmless, and the not for now. Let's take a look. So what's an indemnity? So an indemnity is a promise given by the indemnitor to the indemnity, which is the party that receives the indemnity, to take financial legal responsibility, that's to cover the loss and to accept the legal responsibility attached to that economic liability for a certain loss or a certain indemnified claim or claims brought against the indemnity by a third party. Generally, indemnity does not apply to the claims brought up by the parties in the agreement, but indemnity will apply to claims brought by third parties. That's an important difference with the other two, as the other two will apply both ways, okay? Key characteristics of an indemnity is that the indemnitor is not responsible for the whole claim. It's responsible for the whole claim. And actually, you cannot allocate parts of the claim. So you cannot actually break down the claim and say, well, the indemnitor will be responsible and will bear the result of the adverse judicial decision, but the costs of the trial and the lawyer's fees will be borne by the indemnity. No, it's the whole thing, okay? So no breakup possible, no possible allocation thereof, okay? Sometimes there's confusion, and generally this is something that we specifically address in our legal English course, is how we say these concepts in English, and in our contract drafting course, how we write appropriately the clause. I want to talk specifically about the wording, and generally we say indemnify, save, protect, hold harmless. And I generally get the question, well, more is more or less is more? We generally want the legal wording to be understandable. There is a whole current and more than a current, because it has been going on for more than 30 years, and I totally support it, which is the plain legal English movement. And we are talking about plain English and plain language, not only in English, also in Spanish, con lenguaje claro, and we have the Plain Language Act in the US, and we have also in Argentina our regulations about lenguaje claro, and the need to use straightforward wording to convey as clearly as possible the intention of the parties, and that will help the interpretation of the agreement later on when the conflict arises. So, how do we draft an indemnity clause? Okay, to be on the safe side, use the word indemnity. Okay, generally, it is understood that if I have save, protect, if the meaning is there, it is understood. But in this case of these particular clauses, that we are talking about an obligation that cannot be allocated, but is of the whole, then if you're drafting an indemnity clause, use the word indemnity or use the word indemnify, okay? And there I listed, and I think that you can ask for this presentation and we will give this presentation to you. So I try to make my presentations as detailed as possible so you have all the information within the presentation. So here in Forum Men against Exxon Corp, actually the Fifth Circuit, this is of course US case, actually held that without express language, an indemnity provision will not be interpreted to cover the indemnity's contractual obligation to third parties. So take a look at the wording of the indemnity clause and actually make sure that the words either indemnify or indemnity are there, and that the obligation of the indemnifier to indemnify is clearly set. Okay? So let's talk about non-consequential damages. Non-consequential damages generally appear as releases or waivers. So generally this is requested by contractors that actually want to, for example, cover for non-consequential damages, such as, for example, certain losses that may be potentially large. So as contractors seek this, indemnitors actually seek to carve them out. So please take into account this, and whether you are on one side or on the other, try to include them. And it's difficult to include them, by the way, let me tell you, or expressly exclude them. If you expressly exclude them, it is difficult, however, with, of course, a contract under governed by British or American law. It is difficult that if they are not expressly included, that they will be actually considered as included. But the express exception does not hurt. So here, more is more. Release of claims. Let's talk about release of claims. And I will try to wrap up as quickly as possible. And I'm going to take about 1 hour total. So I'm planning to end at 6:30 if you're calculating your time, okay? But this class is being recorded, so maybe you can catch up later. So let's take a look at release claims. So many risk allocation clauses, in addition to the indemnity clause that we've already reviewed, they include provisions for the release of claims. What's a release? A release actually works the other way, because the party surrenders. It's not here, it's not that I'm covering you of something. It's I make a release that I will not raise a claim against you, okay? So it extinguishes the claim or the cause of action, because actually the person that's entitled to the claim surrenders priorly to make that claim, okay? Again, remember, we are under common law, okay? So forget your civil law knowledge for this moment, okay? So this is possible, okay, to surrender priorly. Why? Because actually a release acts as an affirmative defense, okay? Wording, release, discharge, relinquish. The party relinquish its rights, releases the other party. I vow not to make a claim against the other party, okay? Any provision, any phrase that shows an undoubtedly clear, direct intention to relinquish a given claim or action will be construed as a release. However, again, more is more, please include the word release. It is advisable, okay? I am watching the chat and I know there are some questions popping up. I will address them all at the end, okay? Because some of your questions will probably be answered in the slides that come afterwards, okay? Then we will see another clause that's very common for limiting liability, which is the duty to defend. And here we are moving from the indemnity to a hold harmless, okay? So depending on the applicable law and the language of given contract, an indemnity may or may not include a duty to defend. And here we are moving closer to a hold harmless if it does include the duty to defend. Some courts in the US and in some states in the US, Texas, for example, require that the indemnity provision should expressly state the will of and the intention of the indemnitor to defend and hold harmless the indemnity with respect to the expressly that applicable indemnity, okay? So again, drafting tip, it is good practice to add the word defend. And again, I bow for the plain legal English movement, but you have to include the word. Maybe it is not necessary and it actually is confusing to use 7 or 8 synonyms in this whole long sentences that are more confusing to the reader than enlightening, but use the correct word. And here the correct word is defend. Okay? So the word defend should be there, okay? More if the applicable law is US law, any state, and most particularly if we are talking Texas, Milwaukee also. Okay, so again, the question whether the duty to defend covers all the attached costs or not, then do not, this is not an indemnity. This is a duty to defend. So please be express and add it to the wording, okay? So expressly add defend and cover attorney's fees, court costs, expert witness fees, and you can add a catch-all phrase, okay? And any other cost expense related or in accordance with the matter of the indemnified claim, okay? That should be defined also as well, okay? So my specific advice for you in this particular point is that you specifically address in the provision the defend cost. And I give you examples of the wording that you should include, okay? Defend specifically including any and all costs incurred by the indemnity in establishing the right to an indemnity from the indemnitor hereunder, okay? Or any other similar wording. The key words there being defend and any other costs incurred by the indemnity, okay? Again, this is because in some states, as I said before and named them, the duty to defend and the duty to indemnify are separate duties, okay? Okay, so same basically is always had the word defend, and here you have a specific wording how to add and include the costs involved in litigation, okay? So let's take a look at a typical limitation of liability clause. This is typical when we say that the service provider shall not be liable for any or any and all losses arising out of or in connection with such and such and such, okay? We have seen the indemnity, we have seen the release. Now, let's take this one step further and let's go to hold harmless clause. What's a hold harmless? A hold harmless is basically a statement, okay, that indicates that a party will not be held liable for risk, danger, injury, or damages. Mainly, we're talking damages, yeah, caused by the other parties. Of course, we have a limit here, and generally, we are used that these limits are within the law, but remember, we are in an agreement, in a contract. Agreement and contract, I'm using those as synonyms. That is under a law, under common law system. So I have to state everything in my contract. So hold harmless, that's also called hold harmless relief or safe harmless. Again, hold harmless and safe harmless, synonyms, same thing, okay? Will have the limitation of gross negligence and willful misconduct. Remember, willful is spelled double L first, one L at the end, okay? Careful with that. An eye to the bad. Eso es ojo al piojo en inglés, no se dice, pero yo lo digo. Bueno, What type of hold harmless clauses we have? I'm going to switch, just, I like to just drop in this little jokes because we make this lighter. If not, it is a very, very boring club, very boring classes. I hope not, but basically we have two types of hold harmless clauses. Unilateral or reciprocal, which is what we call a mirror clause, okay? Unilateral, only one part gives the coverage. Reciprocal, both. We will see that knock for knock, knock and knock, actually to work must be a mirror clause, okay? So when both parties are at risk, reciprocal clauses or mirror obligations may be required in order to keep the balance of the financial equation of the agreement. Okay, so let's take a look at hold harmless and safe harmless. I love, and Mariano will follow me on this. Probably he's not now with us at this moment. Maybe yes. But Brian,
yeah, I am here, yes.
Yes, he's with us. He's in the house. So please pitch in and feel free to add anything you like here. But Brian actually, and he has a lot written about this, found evidence that actually they are synonyms. Sometimes lawyers make a big deal about this and saying, well, and I've seen agreements that actually have a hold harmless clause and a safe harmless clause. And that only helps confusion, only makes that agreement will be very difficult to interpret in the future if a conflict arises, okay? So hold harmless and safe harmless are the same thing. Just choose whichever you like, but it's the same thing. If you like hold harmless, how it sounds, it's the most common, but you don't need to have both. So sometimes I say more is more, here less is more. It's not about writing all the concepts, it's about choosing the right one, okay? Because if you put too many, it's like many ingredients in a cake, actually all the flavors confuse. So just choose the right one, okay? So it is true that there have been, and I want to address this issue because there is, and we are talking about common law and we're talking about precedent, and there are some precedents that may find some differences between hold harmless and safe harmless. But the truth is that you should include only one, okay, concept. It's the same thing, goes to the same objective, but don't have both in the same contract or the same clause, because that only entails confusion. Okay? So let's take a look at a basic wording. Okay, company agrees to indemnify, defend, and hold harmless. Okay, here what's the key word? Hold harmless. Okay, maybe it doesn't say indemnify or defend. That's because I have an indemnification and I have as well a defense. Okay, and I may have a release, but that has to be separate. Okay, and hold harmless. The service providers, its nominees, employees, agents, officers, and so on and so forth. Okay, and of course, it has to be limited to third parties that actually do have an interest. Okay, because if there's a third party that actually does not have an interest in the claim, actually the clause will not work. So this works well in the wording, but it should be accompanied by reality, okay? So let's talk about concept. concepts. And now I'm going to go into key concepts of limitation of liability. And one is regardless of fault. And then I am moving away from the classic concept of liability coverage, which is I have to repair a damage if I've caused it. That is basically our civil structure. And I'm going more towards a knock for knock, which is I bear my damages, you bear yours. As long as gross negligence and willful misconduct are not involved, then whoever is at fault, I do not care, okay? So we're breaking ground here, okay? What is regardless of fault? This means to allocate liability to one party or the other, regardless of which the party's fault have risen or have actually caused the claim. This is where we get to the point where we say we need this obligation to be reciprocal. Okay? Generally, knock for knock, and when we are talking about basic knock for knocks, which are knock for knocks that are used in the energy sector, in exploration, in offshore exploration, and you can see if some of you watched the movie Deepwater Horizon with Kate Hudson. If you haven't, please do. Good movie, and actually some scenes are depicted from reality. They talk about knock for knock in that movie, and the reason for knock being mirror is that this mirror obligation maintains the balance of the agreement. And that is why we say that these type of clauses will be acknowledged within agreements, within parties that have the same strength, okay? So I've made the caveat before, then we will talk about carve-outs, but I made the caveat before of when public order or public order matters or, for example, employment issues are involved. So then maybe these clauses will not be considered valid. But within companies that have the same strength, and insofar the obligation is reciprocal, it is accepted, okay? Let's take this one step further and let's turn the screw once more. Okay, so to the knock for knock, I can add pass through. What's pass through? We talked about the obligation of the parties. Now let's talk about third parties, okay? Pass through is used when one indemnitor will indemnify and defend the rest of the parties on the other side. That is to say, not only my counterparty, but my counterparty's contractors as well, because that obligation will pass through, okay? We will see pass-through clauses in many types of contracts, generally in construction contracts. Basically, what a pass-through means is that the terms and conditions of your contractor pass through to the contractee, okay? So when we are talking about regardless of fault risk allocation, we are talking about knock for knock. Okay, so This is going a little bit deeper into the pass-through, and I'm going to pass them through quickly, as many of you maybe are not interested in this, as this is quite specific, but we have mainly three common groups of ways to incorporate pass-through. One is the group of method, which is all the contractors. Other is the assignment method through an assignment clause. And the last one is the specific clause, by which the indemnity adds a provision to each of its contracts and actually can narrow or limit the pass-through in each contract. Okay, so again, what is a pass-through is when the indemnity to an agreement is presented with a third-party claim, and actually the indemnification obligation passes through the contractors, okay? Same thing I explained. And here we come to one of the little pearls. It doesn't exist, the term little pearls. Estoy diciendo perlita. Esta es una perlita. The term does not exist in English. I've just invented it, which is the concept of holding the bag. And this is, yes, a concept in legal English. And it's a concept that actually relates directly to knock for knock. And holding the bag means, básicamente, te quedas a pagar. Se fueron todos tus amigos y te dejaron con la cuenta. Knock for knock clauses should be carefully drafted and carefully balanced so that no party will be left holding the bag, okay? So as long as all provisions are balanced, the claims will be borne in the end by the owner of the property. And remember that in the case of hold harmless, when we are talking about explorations in energy, and I expressly excluded this, but when we are talking about the energy sector, this also covers liability for actually in the case of injury, death, and so on and so forth. But I excluded that because actually we are talking about the new knock-for-knocks that are being included now in services agreements. And we are only talking about commercial agreements that generally are not supported by, they may be supported by insurance policies, but generally they are not, okay? So in the case of the original or traditional knock-for-knock in the energy sector, then the limitation will be also set forth by the insurance coverage. But it's not the main aspect of this class. The main aspect of this class is the new knock-for-knocks used in commercial contracts. So these clauses should be carefully drafted so that they are balanced and no party is left holding the bag with a liability that does not correspond actually to its side, okay? So we'll cover the other party and the other party's contractors, okay? This is something that civil law generally covers with legislation, but there's a void in common law and therefore should be covered by the contract. However, if there is a flagrant despair and actually there is a strong unbalanced, then a claim against this particular clause should succeed, and that kind of clause would, this is my guess, but most probably, and we haven't had yet in the US cases involving new knock-for-knocks as they are being used right now. This is a very, very recent subject, but most probably a court will actually decide with reason, okay? And clauses should be balanced, and therefore we are talking knock for knock. If there isn't another knock on the other side, or the knocks are not balanced, then the clause will not work, okay? Let's talk about fair notice and express negligence, okay? So again, most states in the US have case law that makes, and I'm dwelling in and continuing reasoning on the same concept that I talked just before, that makes unenforceable any indemnity clause that requires the indemnitor to indemnify the indemnity for the indemnity's own negligence, okay, or strict liability or fault, okay, unless the notice is conspicuous, unless there is also a flagrant negligence on the other side as well, okay? So in some jurisdictions, regardless of fault indemnities, it might be unenforceable. So fair notice and express negligence should be considered, okay? So some examples there: Texas, Louisiana, New Mexico, and Wyoming. Louisiana, no surprises there, as it's the only state in the United States that counts with a civil code that has been translated by Mariano, by the way. So let's recap. A knock for knock in a contract states that each party bears its own responsibility for any damages or loss to its own property. Again, accident or injury to its own staff is something that only attains to the typical knock-for-knock used in the energy sector, and that is expressly excluded in these new knock-for-knock that are being included in commercial contracts, namely services contracts, okay, with companies abroad. Most common case is the client is in the United States and the provider of services is in Latin America, okay? Basically, each party covers its own subcontractors' losses and bears its insurance costs if the clauses are tied to insurance policies, as they are tied to in knock-for-knock used in energy. I've seen knock-for-knocks signed recently, executed by Argentine companies that are attached to general liability coverage, que están atadas a un terreno todo riesgo operativo. Lo he visto hace muy poquito. Compañía argentina firmando, proveedora de servicios firmando con compañía norteamericana, y lo ata al TRO de sus facilities, ¿no? Again, no present decisions at the moment, so these clauses may be considered null and void if the parties' strengths are evidently imbalanced, or if the risk covered include legal breach. That's a caveat that I generally have to put, okay? So why we include knock for knocks? Because the intention is that each party knows its jurisdiction, the risks that they entail, and no party wants to actually bear costs that are unknown, that they really cannot cap. So this is a way actually to keep risk controlled and being able to actually calculate risk beforehand. Sometimes these risks and these knock-for-knock clauses are capped. This cap generally is the cap of the insurance policy. Sometimes they are not, but if they are not, they are more likely to be considered null and void. Again, the maintaining of balance is most important. And here we have, again, we do not have a case law on commercial knock-for-knocks, but we do have case law on energy knock-for-knock that actually they considered a knock-for-knock that was valid and protected safely a party from the other party claims for failing to perform a contract. So this is a particularly valuable case law as it involves contract performance. Okay. So features of knock-for-knock clauses include that primary parties and subcontractors constitute a group. The damages and losses suffered by a member of the group is covered by that same group, and the primary party agrees to indemnify all that group if there is a pass-through involved within the knock-for-knock. Which are the exclusions? As we said before, gross negligence and willful misconduct. So these are the borders, okay? The lines. Material breach of contract, consequential laws, and strict or statutory liability, okay? If you have that liability because of the law, then you have it anyway, and there is no knock-for-knock that can cover that. Carve-outs. Let's see what caveats and carve-outs we can include in our knock-for-knocks. Most common, except to its extent caused by such parties, sole negligence, gross negligence, or willful misconduct. Again, if it's by operation of the law. And here I have more perlitas for you. Watch out for these words again. And let's quote Shakespeare, Hamlet, words, words, words. In legal English, the wording is everything, and you have to select and choose your words wisely. So, except to the extent is not the same as unless. Una cosa es salvo. So, beware which side are you on, and whether you want to use except to the extent or unless. Watch out for carve-outs and catastrophic situations, and take a close look at the force majeure clauses. Force majeure clauses have been redrafted and revisited after the COVID-19 situation. Contractors frequently want to limit their total indemnity exposure to a percent of the price or a percent of the amount of the project. But sometimes those limits and caps are not considered. So please take a careful look at the wording, both of the knock-for-knocks and the caveats. Finally, and this is, again, we are narrowing down a little bit too much, but I know that we have in the audience people that do know quite a bit about this. So basically, and I know there are more classifications, but we're going to keep it simple, narrow and broad knock, okay? So the narrow knock is the traditional knock that we've used for many years in the energy sector. And the wording is simply, contractor indemnifies company and its employees or its group, okay? Generally, employees are not covered in these new knock-for-knock commercial clauses for any loss company or its employees negligently causes. These employees wording will be replaced generally by covered or contractors, okay, or indemnities or indemnified persons, okay, where the definition that whether the wording that the drafter chooses for that particular contract, okay, so or any member of the contractor group, okay, generally that catch all goes there, okay? So basically, the narrow knocks covers direct liability only to the group and does not cover indirect liability. The broad knock, yes, covers indirect liability, but subject to the extent of the insurance policy, and generally the broad knock will be followed by insurance policy. I have to be totally honest with you. I haven't seen new knock-for-knock, commercial knock-for-knock, broad knocks. They are all narrow knocks, and generally they only cover the other party and not a whole group of contractors. But this does not mean that we will see this probably in construction contracts as we are tending to go there, okay? Again, mirror, mirror on the wall, who's the fairest? And I like to make a pun of words, P-U-N, un juego de palabras, here, because fairest here es quién es la más linda, pero yo quiero decir quién es el más justo. Entonces necesitamos que el knock for knock sea una cláusula espejo y que las partes tengan igual poder de negociación y de fuerza y estabilidad y capacidad económica. Okay, so let's take a look at the wording. This is one of the new knock for knock. Covers property, covers company, group, may cover injury or illness insofar it is contemplated in the insurance policy. If not, that part will be deleted and off, okay? So basically, the difference between the knock for knock and the hold harmless, that is what we have seen most commonly up till now in the commercial agreements, is that the knock for knock, each party covers its own damages and the other party does not litigate. Whereas in the hold harmless, actually, as it's an indemnity obligation, the other party has to go litigate and then recover, okay? What can we say about the new trends in limitation of liability? the rationale for knock is primarily economic. The parties want to allocate the risk beforehand and want to know how much that contract will cost them, period, without any surprises, okay? And want to actually avoid unwanted litigation in jurisdictions they don't know and they don't want to know. There is some room for challenging these clauses based on public policy and, again, the relative strength of the parties to contract. But insofar as the strength is equal and the clauses limit only to direct damages, these clauses will be reputed legal and valid, okay? And more are being used and requested by our clients, mainly from the US, okay? Common law courts and arbitrators will tend to interpret the agreements strictly, okay? Looking at the four corners, and this comes from the four corners of the sheet, okay? And the granting of reliefs will be, and injunctive reliefs will be exceptional, okay? And based on equity principles. And in civil law jurisdictions, and when one party has its legal domicile in a civil law jurisdiction, despite actually contracting under common law, actually the civil law party will tend to try to bring that claim to its jurisdiction. But actually what the parties will need to do is actually then to face litigation in that case and then settle the matter between themselves. Okay, hope I have been clear. Hope you have understood a very complex but very actual issue. And now I will go to the chat. Can we use knock for labor liabilities? No. Unfortunately, that will, the labor liability actually will, labor relationship will be guided by the law of the country where the employee actually has its domicile and actually performs its duties. But this kind of clauses, these clauses actually knock for knock is being included in services contracts. And sometimes there are some services contracts that, again, because you have a self-employed person on the one side and a very big company on the other side, then the services contract blurs a little bit. The services contract title blurs a little bit, and it turns into an employment contract. So I should say that in that case, you have, of course, to look at the fine print and look at the whole contract. But in that case, the knock for knock could be considered null and void, okay? Could you please elaborate on the dichotomy of the existence of a cap limit in a K4K scenario versus the insurance cover? Well, that would depend on the insurance policy, actually. Two things. The the wording of the clause and of the whole agreement, because there you have to look at the whole agreement and whether a severability clause is included, whether how the definitions work, and the insurance policy. And this question, I think that's more related to the common traditional energy not-for-nots, okay? So I don't know if that, Luis, if you consider that has been answered. Can we use for labor liabilities? I think not, and I have already addressed that. Do you consider that the scope of not-for-not clauses can be limited? Yes, they can, and they are. And I've addressed that profusely. How do you reconcile such liability scheme with inclusion of caps and the exclusion of consequential damages? I think that's absolutely right. And actually that brings the inclusion of caps and the exclusion of consequential damages is what makes a not-for-not reasonable and therefore valid, okay? So totally agree with you on that. Tamara, would it be similar to the clause by which the insurer is obliged to assume the legal defense of the insured? And not precisely, but there are some similarities, as in a hold harmless clause, it is common that many times it's the indemnitor that takes over the defense. So yes, generally there is an overview and a control in a hold harmless. Here in a not-for-not, and I want you to have this very clear, this will be similar in a hold harmless, where actually the party that's indemnifying wants to make sure that the trial, the lawsuit is followed correctly and the claim is defended actually it's defended well and not with negligence. But in the case of the not-for-not, this is not an issue, because actually the party that's being indemnified never goes to court. Release waiver, yes, a release is a waiver. Clear and unequivocal terms under the law of Louisiana versus express negligence doctrine. I don't understand this. Probably is not a question. I think that maybe I made that note, but it's actually it was a note for self that that's actually two states that require the notice and require certain, as I mentioned them, require that certain requirements are met for these clauses to be acknowledged. Is there any similar institution to orden público that may limit it? Okay, so as I said before, it would be the consideration of there are limits, and this will be reasonable. This, of course, should be considered by a court. And yes, of course, these are clauses that are controversial. And if they are not well written and balanced, then they might be considered null and void. That is why I always recommend to have a severability clause, so that any clause that's reputed null and void does not import or involve the the consideration of the whole contract being removed. Okay. What about arbitration? Is it possible to include an knock for knock in the well, arbitrators are considering knock for knock clauses and will consider these clauses valid as long as they are reasonable. If you have a knock for knock clause in an arbitration agreement, I don't see where the claim may be, but I don't understand the question. Could you talk about and explain us the negligence doctrine? Actually, this escapes, and we are within our time limit because it's now we're past our time limit. It's not, Matthias, I would love to have a one-on-one chat and I explain, but we're talking about willful misconduct or gross negligence where there is a clear proven negligence, not actually a subject of this class. So I'm sorry, I cannot address that at the present moment. Even under civil law, we could agree to a different remedy and parties will prevail. I really don't know. You have to actually, take a look at, actually, we have to consider each case in particular, actually, the law of civil law of which country we're talking about. But I think that actually under a civil law agreement, under an agreement under civil law with governed by civil law, these kind of clauses maybe won't be necessary because you have enough remedies in the law and they work other way. And I think we should check and see how the courts would react to this, but I would think that they would tend to use the remedies that are provided by the law. So I would say that insofar as what I've seen now, these knock-for-knock clauses are being included in contracts under US law. So under laws that are within the scope of the common law. Okay, so I think I've covered and I have more. Okay, thank you very much. I think I have no more questions left. If I have another question, yes, the Zoom is recorded, so you can access this class later on. And I think that this class will be recorded in the YouTube channel that Austral University has. So thank you very much. Gracias, Augusto. Gracias, Tamara. A lot of friends and colleagues. So Mariano, thank you. Thank you, everyone. Thanks for joining, for tuning in. You can watch the full class in our YouTube channel. And well, hope to see you with our legal English course and our upcoming workshop on contract drafting in October and November this year, both at Universidad Austral. My name is Consuelo Conti-Toutin, and I am very happy to have hosted this masterclass. Hope you liked it, and any questions or queries, please feel free to have them sent to us through Karina Molina, the same contact where you registered. Okay, thank you very much and see you soon at any of the courses in our crowd. Thank you very much for joining us today. Good afternoon and have a good day.